Mr. McGlynn.
My Lord and ladies, we've sent some materials into the court over the short adjournment, the 1959 Act, the 1961 Act, the McDermott report from 1981, and the 1979 command paper, which preceded the 83 Act in England and Wales.
Well, that's excellent. These have been sent to registry.
Yes.
Fine. We don't have them yet, but they'll find their way
I
to us.
don't propose to refer to any of the detail, but the court will have it in due course. Moving back to the tribunal decision, which the court had been examining for the adjournment, and the cross-referencing between the reasoning in the tribunal and the statutory provisions. If the court has page 543, paragraph 41 of the tribunal decision, it's not very clearly flagged in the reasoning, but this is the part of the tribunal decision where they deal with the Article 77(1)(a) criterion. And that, we say, is clear from reading the totality of the paragraph. You turn over to page 544, you see the tribunal say that they then considered whether his discharge would create a substantial likelihood of serious physical harm to himself or others. That's the Article 77(1)(b) criterion, and the reasoning follows then from 43 through to paragraph 47, where they say, for the reasons given, satisfied that his discharge would create a substantial likelihood of serious physical harm to others. And then they express it in terms of directing that he remains a detained patient, but that's a refusal of the discharge application.
What does, excuse my ignorance, but what does dynamic risk mean? In 44, Mr.
Yeah.
Dynamic.
This is one of those psychiatric assessment tools called Armadillo, which there are static risk factors and dynamic risk factors. And all I can say is that dynamic is factors that are subject to some sort of change. I'm not sure exactly what they are.
All right.
There's no engagement with Article 78 because the A and B components are not met. The tribunal stops at that juncture. That's the operative decision.
Well, it should. I think they. Well, C would only apply if it was a case governed by to which Article 71(4)(a) applied.
Sorry, I missed that one.
Well, 77, there are three possibilities, A, B, and C, and you've shown us how A and B are dealt with. That C only applies in the case of an application by virtue of Article 71(4)(a).
Yes.
So unless this was such an application, there'd be no need to consider it.
Yeah. 71(4)(a).
Takes you back to Article 14(4).
Yes, which is a Part 2 application.
Right.
So
but it doesn't apply.
That's not this case. This is a Part 3. Just check that.
Presumably, because of the tribunal's views on A and B of Article 77, you don't get into 78(1)(b.
Exactly.
Is that correct?
You stop at that juncture. Doesn't proceed past 77. The 77(1)(c criterion is not engaged because that's. I'm just cross-checking, but I think that's a Part 2 case.
Yeah, in fact, and it isn't subject to the cross-reference in 78(1)(a), which would also indicate it's a Part 2 case rather than Part 3.
So that's 14(4).
There's an explanation of the risk factors and dynamic risk and so on at pages 468 to 469.
Yes. That falls within the RMO's report.
It explains the armadillo tool. I don't know if we need to take time on it, but
Yeah.
Lady Rose might find enlightenment there, possibly.
Yes. I think I was broadly right in my description of it, but the details in the RMO's report. And of course, that's important in the scheme of things because the RMO, as we've seen, is responsible all the way through for this, and the RMO is the person who's superintends the Article 15 leave if it is granted. And this is a case where I think this patient had been subject to a number of minor episodes of Article 15 leave, so the short visits out, but up to the juncture of the tribunal, he had not yet had a testing period of leave, i.e. in the community for overnight or for a period. That was about to come. That was the next stage of the process at this juncture. So when the tribunal make their decision, he's not yet been tested. This is all prospective. The High Court decision then upholds the tribunal's decision, and in fact, this patient was then subject to Article 15 leave from, I think, March 2021.
Did he progress?
He has remained on Article 15 leave for an extended period and is progressing towards conditional discharge. Doesn't support it. Yeah. The department had been opposing conditional discharge in this case for a period of time, but no longer does so. So the trajectory for this patient is Article 15 leave towards conditional discharge. Two conditions less than deprivation of liberty, not engaging the M.
Is that the significance of MM, that the
Yes.
conditions must be less than deprivation
Yes.
of liberty? And one might raise an eyebrow at that, but I understand MM's not an issue and its correctness is not an issue in these proceedings.
No, it does warrant a raised eyebrow, I think, because there's debate to be had about that, I think, and
But not for today.
not for today.
We might need 7 pairs of eyebrows to.
Yes, 14 collective judicial eyebrows would need to look at it, I think, but it is a topic worthy of consideration. It's not critical to this appeal. There's been no request for the court to convene as 7 to overturn it.
Is it going to be resolved by the new legislation?
Well, if new legislation is enacted, the legislation was not in the King's speech for this Parliament, so it depends. The proposal for the bill is to have a supervised discharge provision, which would meet the problem.
But I thought the new Mental Capacity Act was enacted.
In Northern Ireland?
Yes.
No, there is a new Mental Capacity Act in 2016 that's been enacted, but it doesn't address this issue. So there's no Northern Ireland provision, freestanding provision anticipated to address M. There is a primary legislation proposal at Westminster to address the issue generally, but that will require parliamentary time that's not going to be available in this session.
Addresses it in relation to England and Wales, but not in relation to Northern Ireland.
Yeah, if it comes,
For that, you need to have a government.
well, yes,
Assembly.
that's a perennial problem, Lord, but yes, it might be possible to do it,
It could be. It might.
but difficult. So we do have an ongoing problem in Northern Ireland. The M issue cannot be addressed legislatively at present. Whether it's addressed in England and Wales is really a matter for Parliament.
So instead, there's guidance for
Yes.
officers as to what conditions would amount to something less than deprivation of liberty for the purposes of conditional discharge, or is it all leave of absence?
There's guidance which is directed towards using leave of absence
Right.
with conditions that would amount to deprivation of liberty.
Okay.
So that meets the M problem. So there's a cohort of patients, not a huge number, but significant number, who, because of their organic illness, will not recover and who will always require deprivation of liberty. And for that group, it's not in their therapeutic interest to be detained in hospital. In order to facilitate that, the Ministry of Justice have issued guidance, which is in the papers, as to how extended leave of absence can be used. Why does that matter for this appeal? Well, it matters for this appeal in the sense that we are now discussing the legality of leave of absence provisions in Article 15, and what this court says about it may have an impact or bearing on the utility of that guidance. May not, but it may do.
Look at paragraph 6 this is what I had in mind, of the case for the respondent at page 187 of the bundle, that I thought was saying that there is now an act which is going to sweep away Part 3 of the mental health order and replace it with Part 10 of this new act.
Yeah, that legislation has been on the books,
Yeah.
but it's not commenced, and there's no present proposal to commence it. So there is a text, but it's not in force. So we don't consider that the Mental Capacity Act 2016 is a solution to this problem.
But would it, if it were, does it deal with people like RM who have capacity?
Well, it generally doesn't deal with Part 3 patients. So persons who are, the mental capacity legislation, like the Mental Capacity Act in England, is not dealing with detained patients.
Well, at some point, could you have a look at what's said in paragraph 6 and see whether you agree with it?
Yeah. I don't think you have the Mental Capacity Northern Ireland Act 2016 in the papers anywhere, but
No. Well, I'm not asking for it, but it just struck me as strange, if it's to do with people without mental capacity, that it says it replaces all of Part 3, which seems to deal with people. Well, I suppose capacity is not a binary thing, is it? You can have capacity for different.
This patient has capacity sometimes for some things and not others,
Yes.
but this patient and the difficult cohort of patients are those who have capacity. So they're probably not going to be dealt with by the putative Mental Capacity Act. And that's true also of England and Wales, where we have a Mental Capacity Act here. But the difficulty that arises here is we have detained Part 3 patients who have capacity. I mean, the patient here has capacity to agree to the deprivation of liberty.
Except for M.
Except for M, exactly. So that's the problem that we have. So, yes, there are legislative solutions. Northern Ireland's not commenced. We don't think it deals directly with this issue. England and Wales' proposal for primary legislation may not proceed. If it does, it may introduce a supervised discharge provision that will address the problem for England and Wales, but not necessarily Northern Ireland, as Lord Stevens points out. I don't want to take time up with the M decision, but for your reference, it's at page 971 of the Book of Authorities. They're, again, not going to dwell on it. There's the majority decision of 4 justices, minority decision, single dissent by Lord Hughes, and there is a debate about whether there really is a deprivation of liberty problem whenever you're moving someone from a condition of detained deprivation in a secure unit to restrictions of their freedom in the community. So from a fairly rigid deprivation of liberty to something lesser than that. And that's the context of that debate, and the majority considered that was a deprivation of liberty that couldn't be authorised consistently with Article 5. So, and you'll see in the papers that that decision, which was 2018, predated this case coming to the tribunal. It first came to the tribunal in 2019. At that point, what was being mooted for the patient was conditional discharge with those sorts of conditions, and the tribunal adjourned to try and find a way around the problem. And there were various High Court applications. There was a habeas corpus application, judicial review application, application for declaratory relief, all trying to find a way through the problem. None of that came to anything of substance. The judgments were all in the papers. I don't think you need to look at them. And it was after all of that we came back to the tribunal in January 2021 with a different medical analysis, now saying not recommending conditional discharge at this juncture, but recommending Article 15 leave. That's where we've got to. And High Court judgment of Mr. Justice Colton upholds that by reference to some English decisions. They're all first instance or some Court of Appeal decisions about what type of clinical engagement is required to satisfy the statutory requirements. So that's where we've got to. And just, if I can pick it up there, I just wanted to show the Court some of those decisions so you can see how the courts have dealt with discharge, mostly of civil patients in this scenario. And I'll show you three. These are all early 2000s decisions. Epsom and St Helier and W, I think. You find it at page 910 of the bundle. This is a printout of High Court decision. Mr. Justice Sullivan, a challenge from the Trust to the Tribunal. And this was a challenge about discharge in respect of a patient who was receiving very limited clinical treatment at that juncture. But the value of the decision is in the summary of the principles, and you'll see that picked up from page 923. And the court there is saying the tribunal was right to reject the argument that the patient was automatically entitled to be discharged under Section 72 purely by virtue of the fact she's not receiving any element of inpatient treatment whilst on Section 17 leave. So it's a little bit analogous to this case. This case, the patient is also arguing that they're not receiving that type of treatment. And then the points of principle that come out of that at paragraph 47, reference back to an earlier case of B, that you should look to the whole course of treatment, look to the past, present and future. It's not enough to say that a patient is not receiving treatment at a particular time. Paragraph 48, the correct approach to Section 17 and 72 is to recognise the progressive nature of treatment in many cases, and a reference to Lord Justice Thorpe in B. And then, again, reflecting that there should be progressively longer periods of leave. It's important there's no artificial cut-off requiring the tribunal to look simply at whether inpatient treatment is being provided. To do so would not be in accord with the aim under Section 17. Paragraph 51, the second sentence, the likelihood of treatment being required in the future within the period of retention is plainly irrelevant contention. And 52, the matter is to be looked at generally in the round. Then another of the frequently cited decisions is that of Mr. Justice Wilson, as he then was, in DR and Mersey Trust. You'll find that at page 888 of the bundle. Sorry, is that right? Tab 11? Yep. Ah, sorry, yes. Yeah, thank you. This is another civil patient admitted through Section 7.3, the Mental Health Act, with schizophrenia. The facts are set out, page 892. and the issues of principle are picked up at paragraph or page 902. And this is a case about whether or not inpatient treatment was a requirement. And paragraph 29, page 902, and Justice Wilson's picking it up towards the bottom of the page. The significance of the Barking case is that renewal was lawful, notwithstanding only part of the plan was for treatment in hospital. It sufficed if that part of the plan was, to borrow another phrase from Judgment Lord Justice Thorpe, an essential ingredient. In my view, being impermissible, indeed an illogical gloss upon the Act to make lawfulness depend on a plan to put the patient at times into a hospital bed. No magic in a bed. Facility for treatment at night be less for treatment during the day. The question in my judgment is whether a significant component of the plan was for treatment in hospital, and then refers to the English definition of medical treatment, slightly different in Northern Ireland. And you'll see there it says, there's no doubt therefore the proposed leave of absence for the claimant is properly regarded as part of her treatment plan. As paragraph 21 of the Code of Practice says, leave of absence can be an important part of a patient's treatment plan. If purpose referred to the claimant's link with the community, reduce stress, so on and so forth. And paragraph 31 holds a significant component of the plan was treatment in hospital. Conditions for renewal set by 20 subsection 4 were satisfied. Now, reading that across to the kind of case we're dealing with here, this is a case where there is a care plan. The definition of medical treatment, I should point out in the Northern Ireland legislation, is slightly different. So you have section 145 of the English Act. Should probably show you that. Page 700 of the bundle. The definition of medical treatment in the Mental Health Act 1983. In the middle of that page, medical treatment includes nursing, psychological intervention, specialist mental health rehabilitation and care. And then subsection 4 also applies. That's on 701. Reference to medical treatment shall be construed as reference to medical treatment, the purpose of which is to alleviate, prevent a worsening of the disorder or one or more of its symptoms or manifestations. The Northern Ireland definition is slightly less elaborate. That's found in Article 2 of the Northern Ireland provision, page 716. Halfway down the page, medical treatment includes nursing, also includes care and training under medical supervision. So care under medical supervision, you can compare that with the evidence of Dr. Devine, and we say that seems to meet the test.
I don't believe there's any dispute that the treatment plan of allowing people to go into the community and being tested in the community is medical treatment. And what I was interested in is using Mr. Justice Wilson's remarks at page 903, where he says, no doubt, therefore, the proposed leave of absence for the claimant is properly regarded as a treatment plan. And I don't understand there is any dispute about that. Yeah. And then you read that across to Article 77. RM is suffering from a mental disorder, and that treatment plan can only be provided under Article 15 if he is detained.
Yes.
And so...
Or on leave of absence, my Lord.
Or on leave of absence.
He's liable to detention.
Yeah, he's liable to be detained.
Liable for detention.
Yes.
And so if you have the 77-1A test, in order to enable him to have that part of his treatment plan, he has to, his detention in hospital for medical treatment is justified,
yes.
Is warranted.
Yes.
And in a sense that gets you away from any question about whether it's a significant part of the treatment, because you can rely upon the first reason that Mr. Justice Wilson gave. And he needs that treatment plan. It could only be given if he's liable to detention. Therefore, he's liable to detention in order to give it to him. And after a period of time, when he's made the transition into the community, that's no longer a part of his treatment plan.
Yes.
So that removes any test about significant connection or whether the connection is strong enough and so on.
Lord, you'll have picked up that the department and the tribunal, or certainly the department, were not making a case based on these authorities to the tribunal. The department were really saying, just by the application of the statute provisions, this is the appropriate way to deal with this patient. It's the respondent who's saying, hang on, there are these decisions in England, and when you compare the facts of those against our facts, we're not on all fours with them. That's how this issue emerged. So it's slightly collateral to the legal debate. But the respondent's case is, we don't match up to the facts of the English decisions. That's the case they took to the High Court. That's the case they took to the Court of Appeal. And the Court of Appeal then went off in a slightly different direction, saying, well, those decisions are actually not applicable because we're dealing with a different test. But it's never been the department's case that we have to satisfy these sorts of thresholds. It so happens that if we did have to map across to these authorities, well, we say the Northern Ireland situation with this patient meets them comfortably.
Can I just ask you a question about this language, liable to be detained or liable to detention?
Yes.
Has an exercise been done to identify where in the order and indeed in the Act it's used? We've looked at it in various places, so Article 15, Article 47, Article 78. It doesn't seem to be a term that's defined as such. So I just wondered where we get the best clue as to what it means, liable to be detained rather than detained in fact.
Yeah.
Can you help with that?
I think the best treatment of that, I'll just check with my juniors, is in the Barking decision. Is that right?
Yeah.
Yes. Barking, Havering and Brentwood Community Healthcare Trust, ex parte B, is at 854. This is a judgment of the Court of Appeal led by Lord Wolfe. And it's one of those cases where there are two patients involved here. And the issue about them really is that they won't take their treatment. So they're not cooperative with treatment that they need for their mental health condition. But in order to get around that problem, the powers of detention are being used against them. So they're being detained not for the purpose of treating the disorder, but to make sure they will get their medication. So it's considered to be a potential abuse of the mental health legislation. And that point is picked up in a case called Hallstrom, which our Court of Appeal rely on. And then Hallstrom is analysed by Lord Wolfe in Barking NHS Trust. And you'll see the part of the judgment that goes to the issue that Lord Sales is asking about is at page 860. Picking it up in the middle of the page there, it's a reference to the Hallstrom decision. Both W and L, those are the patients, had a long history of medical treatment for mental illness, but they would not accept the medication which doctors considered they needed voluntarily. W was therefore detained by the doctors implementing provisions of Section 3, and L was renewed under Section 20. On both cases, the action was challenged because they were not liable to be detained. It was accepted they did not require treatment as inpatients. The real reason for their actions was their refusal to take medication, which could have been taken as outpatients if they'd taken it voluntarily. And on the facts, in Hallstrom, the High Court judge found their detention was unlawful, but then went on to discuss the question of what it meant to be detained or liable to be detained, and you'll see that following in the paragraphs beneath that. And there's then a lengthy discussion of what the correct approach is to detained and liable to be detained. I'll just flag that for the court at 861. And if you go to 862, The second paragraph, reference to the Brenda Hale's text, Mental Health Law, 1996, suggests the change in language may be a draftsman's slip. On my reading of the 1959 Act, that's the English 59 Act, liable to be detained is used both to cover a person who is detained and a person who would be detained if he were not on leave. So it's both scenarios. The opening words of Section 23 require the responsible medical officer to examine those who are liable to be detained. This literally applies to those who are on leave, but must also refer to those who are detained.
As I understand it, the problem, as the Court of Appeal saw it, with the tribunal's decision, was that if the tribunal concluded that leave was appropriate under Article 15, then it followed that the person's detention in hospital was not warranted, and therefore the tribunal should have concluded that it wasn't satisfied in terms of 77(1)(a, and therefore discharge should have been ordered. The problem with that is that patients generally are only going to be in the hospital in the first place if they meet the requirements in Article 4, which we saw include a requirement that the person is suffering from mental disorder which warrants his detention in a hospital.
Yes.
And it's people who meet that criterion to whom Article 15 can apply. So anyone to whom Article 15 applies and is given leave of absence under Article 15 must be somebody who meets the condition in 4.2a.
Yes, it has to follow.
Their detention is warranted.
Yes, and they're either detained or liable to be detained.
Well, 4.2a is detained.
Yes.
Or warrants. Your detention has to be warranted. That's the test.
Yes.
And I'm not sure. I think that's the basic problem with the Court of Appeal's reasoning.
Yes. I'll come back to the problems of the Court of Appeal's reasoning, of which that is one element of it. I've taken you to...
Now, their approach, when could Article 15 ever apply?
Never, on their approach. That's my submission is, it can't be right that you take Article 15 out of the toolbox, particularly in a context where M has had the effect of taking conditional discharge out of the toolbox. We're then left with the starkest scenarios of continuing detention for patients who don't warrant it, or absolute discharges.
Well, certainly 15 would be out of the toolbox unless it was accompanied with keeping them in custody. But it does, Article 15 does envisage that they may be on leave and not in custody, but still liable to be detained. And
yes.
It's that conundrum that the Court of Appeal is dealing with.
And Article 15 is a very flexible instrument. I mean, Section 17 leave in England, Article 15 leave in Northern Ireland is flexible. It can be for short periods of time. The English statute provision under Section 17.2 allows for it to be indefinite. So you can have indefinite leave of absence under Section 17. The Northern Ireland provision in Article 15 doesn't use the word indefinite, but allows for it to be renewed for any period of time. So it can be used in a particularly elastic way to meet the particular needs of a given patient. So it underscores my response to my Lord Reid, that if the consequence of the Court of Appeal's decision is that you can't use it at all, that's deeply problematic. It's hollowed out a major part of the public safety protection and the therapeutic protections of the mental health legislation.
So just going back to what I was asking for assistance with, the phrase liable to be detained, is this right? On your submission, it's a reference back to Article 4 and continuing satisfaction of the preconditions for someone to be detained in hospital for treatment. We know, in addition, I think Article 47(2)A, in effect, defines a situation where, if you like, it's deemed that someone is liable to detention.
Yes.
But is the first part of what I put to you correct? That
First part's correct, yes.
That is how one knows whether someone is liable to be detained.
Yes.
There's an ongoing satisfaction of the preconditions in Article 4.
Yes. For
Okay.
Well, can I just ask, just to make sure I've understood this, Article 4 is dealing with the ordinary run of civil patients.
That's the assessment provision for civil patients. It might be Article 12 that's more
12,
appropriate.
yes.
Article 12 is the detention treatment patients in the Northern Ireland context. Section 4 is the Mental Health Act.
If you're a Part 3 patient, your liability to detention flows from the
Court order.
order.
Yes. It's easier. This is an easier case because we know it's like having a certificate of conviction. We know that there is a hospital order in place. Therefore, you are either detained or you're liable to be detained until some other legal instrument nullifies that order or it expires by the elapse of time. So it's amenable to...
That's what I meant, but when I was saying it was definitionally so under Article 47(2)A, because that is saying what happens where you've got a restriction order in place. But the liable to be detained in a hospital in Article 15 has to work in both...
It works in Part 2 and Part 3.
And Part 3, and I was just trying to see how you said it worked in Part 2.
Part 2, in the Northern Ireland context, it works through satisfying the Article 12 criteria for being...
Strictly, would it be at 4 and 12?
4 and 12, sorry.
So either
Yes,
of those.
4 is assessment and 12 is detention for treatment.
Okay.
Works for both of those. The other route in is through Article 47, restriction order 2A.
But then how do you avoid the conundrum with the person who's a civil patient, as you've called it, that if they don't... that if you're considering granting them leave to without custody and potentially indefinitely, then you can't be satisfied that they need to be detained in hospital. How do you get round that in the way that whoever it was in this, Lord Wolfe says that it's either they're actually in hospital or they would be detained if they were not on leave? Is that how you...
I think, well, how it seems to have been dealt with in the case law is to take a more elastic approach to what is involved in treatment in a hospital. So in almost all of these cases, there will be some interface with clinical intervention, sometimes inpatient, sometimes RMO review, and provided there is some significant component, that's how Lord Wolfe puts it, then you satisfy the test.
I mean, it's not a completely unfamiliar situation. If you, in the days when I used to sentence people to imprisonment, there would be literally a warrant to the governor of whichever prison they were being taken to, and the warrant would authorise the detention in custody for a term of whatever it was, how many years. But nevertheless, the prison governor would be able to grant absences before the term of imprisonment had ended, in order to attend a funeral or something of it. The effect of a warrant isn't to require that the prisoner be physically locked up for the entirety of a period.
I think that's true. I think all jurisdictions in the United Kingdom, the prison rules allow for a facility for governors for compassionate temporary release, medical treatment, police interviews for about another offence. So you're not necessarily imperatively detained where you've been sent from beginning to end. There's always a facility for release. And what happens here is the double protection is it's the RMO says Article 15 leaves appropriate with the agreement of the Department or Secretary of State in England and Wales. So it requires both of those in order for a criminal justice patient to be released. That's not surprising. And the RMO alone can, or the Secretary of State can have them recalled. So it's potentially indefinite or for a very protracted period of time, but can be brought to an end very quickly. So it's a very flexible tool, not unlike the sorts of things one gets with sentenced prisoners on licence, leaving aside the special compassionate temporary release type arrangement. This is like licence conditions. So
there's an interesting discussion at page 898 about the meaning of the words liable to be detained, which relates to section 24C of the 1983 Act. So if a person is admitted for treatment, the admission is only for a period of 6 months, unless it's extended. And the requirement under section 24C is that unless he continues to be detained, and it was so that you couldn't extend unless he continues to be detained. So the court in this case held that that meant unless he continues to be liable to be detained, and not unless he continues actually to be detained.
yes, and that's to address a rather odd situation which was happening, was people who were out on leave were being brought in for the artificial reason of being detained so that they could be extended.
But the word detained was being interpreted as liable to be detained.
Yes.
And accordingly, the word detained in Article 77 could also potentially be interpreted as liable to be detained.
Yes.
And in the case of what we're calling civil patients, you could only be liable to be detained if your detention was warranted in terms of Article 4.
Article 4 or 12 on the way in. Yes, exactly.
Yeah, I mean, I suppose one way of looking at it is liable to be detained in the absence of a specific court order is given by the underlying legislation, because it stipulates certain conditions which have to be fulfilled to authorise detention, and those need to continue to be fulfilled in order for you to be liable to be detained if you're not already. But if a court order has been made, that in a sense takes over from doing the work of the legislation itself, because you've actually, the court has looked at this individual case and made an order accordingly.
Exactly, and that's why I don't want to overstate the utility of these, what we're calling the English authorities, because most of them are actually civil Part 2 cases, where we're grappling with the underlying statutory framework and whether that gives rise to liability detention. That doesn't apply, and I don't think any of these decisions, except the most recent one, EG, are Part 3 cases, because the Part 3 case has liability to detention built in already by virtue of the orders, the hospital orders. So, and again, the department wasn't playing these cases into the litigation. That's the respondent, because they want to make a point about, well, the facts are different, they're not quite the same, and that.
Can I just fully understand what you're saying? If you look at Article 77(1)(a), page 781, and the concluding words, detention in hospital for medical treatment, you're interpreting that as liability to be detained in hospital for medical treatment. Is that right?
Yes.
Yeah, that's fine.
And if that's right, then issues about the civil authorities are, well, they're informative, but not making a huge difference ultimately. And you'll see that Justice Colton referred to the CS decision. Again, just to cross-check, that is a civil Part 2 detention, I believe.
So, I'm so sorry, just on Article 77(1), which I was just looking at. I mean, there's, again, a slight curiosity, because the opening words say, where an application is made by or in respect of a person who is liable to be detained. But the point of the application is to see whether he is liable to be detained. So it's a bit odd that the opening words kind of presuppose he is liable to be detained, where that's the very thing which is now being examined. But well, maybe that's just another oddity we have to put up with on yours.
Another curiosity, it may be because 77 is about discharge of Part 2 and Part 3, so it's Part 2 patients and Part 3, and it brings in the restricted patients through Article 78. So, yes, you've got to come before the tribunal for a consideration of discharge. If you're a Part 2 patient, the question of whether or not you're liable to be detained is at large, because we have to look at the statutory factors and see how that fits. If you're a restricted order patient, it's different, because the liability to detention arises from the order.
But Article 77(1) is primarily to do with Part 2 patients. So
yes,
the oddity, which I was putting to you, arises on 77(1). But maybe that's just where we are.
I think it's...
Is that right? If with a civil patient, suppose that both the patient and the RMO think that it's fine now for them to be released, does there still have to be an application to the tribunal, or is that only when it's contested?
Department's condition. Yeah. Yeah, no, I think you don't require the tribunal to release where you've got a civil patient and the RMOs agreeing with the patient that the criteria aren't met. So that doesn't engage the authority of the tribunal. Yeah.
Because at the end of 78, where it says it's without prejudice to Article 48, that I understand it is where the Secretary of State, where the Department of Justice is content for the person to be released. So again, I think 78 is also only when it's contentious. So yes, there is this.
Well, yes, you can.
Oddity.
Section 48. That's page 765. Yep. Is a power now vested in the department.
Yeah.
48 subsection 2. At any time where restriction orders in force, the department may, if they think fit, by warrant discharge the patient from hospital, absolutely, or subject to discharge. So there's a freestanding power for the department to do that.
I caught a helpful stage whisper directing our attention to Article 14 on page 733.
Yep.
Which is to do with the discharge of somebody liable to be detained by the RMO.
Yes. So what that amounts to is there are routes out of the system other than through the orders of the tribunal. It's where there's opposition to that, RMO saying no, or department are objecting, or the clinical evidence is conflicting, that you may require a tribunal determination. That engages 77.
It is important for the system to work that it's the cessation of the person being liable to be detained depends on a decision to that effect of somebody rather than merely the cessation of applicability of the test. Otherwise, everyone could say, well, the RMO, yes, you've taken your decision that I'm no longer liable to be detained, but in fact, for the last 3 months when you've been mulling it over, I wasn't in fact liable to be detained. It's not something that's just happened yesterday. But then it doesn't work for the liability to be detained just to evaporate on the occurrence of some facts that nobody's turned their minds to.
There's a symmetry with the way the system's meant to work on the way in, as I'm putting it.
Yeah.
You don't get into the system unless someone makes a positive decision that you meet criteria. You don't get out of the system unless someone or the tribunal makes a positive decision that the criteria are not met. It's not simply a state of affairs that someone makes a...
Yes.
It has to be a positive determination.
I think what my lady is saying is actually an answer to what I was posing as an oddity in 77(1 is liable to be detained. Because in a sense, you are liable to be detained because an RMO, someone has said you should be detained until such time as either under Article 14 they say no longer. Because Article 14(1) says, person who is for the time being liable to be detained shall cease to be so liable if that happens. But 77(1) is addressing a situation where the RMO is saying, no, still keep detaining.
Yep.
And therefore, they are liable to be detained unless and until, in effect, the tribunal does what the RMO could have done, which is say, no, they must be released, in which case they cease to be liable to be detained.
Yes.
Yes,
77
the
is...
liability to detention, if you're a Part 2 patient, is temporary.
Yes.
By virtue of Article 12.
Yes.
It's for 6 months or 6 months or less.
Yes, it will expire either by a decision of someone else, the RMO, by the Department of Justice under 48. Sorry, the Department of Justice doesn't apply at that stage to that's for the restricted patients, or by the elapse of time. For the restricted patients, it's Department of Justice decision under 48.3, or if it's a contested issue, it's a tribunal decision. There has to be a positive determination at that point. So the question of liability to detention is a legal question. Are you meeting legal criteria by various routes, either Article 4, Article 12, or the hospital orders? And those,
it's a legal status rather than the factual underlying status. Yes.
It's a question of, are the legal ingredients in place? If they are, you remain liable to be detained.
Yeah, or perhaps not so much legal status as existence of authority that you'd be treated with in a particular way. That authority in the Part 2 Article 12 case stemming from the decision of a medical officer. And I think, as my lord points out, that's time limited anyway. So that authority only lasts for so long, unless and until it's renewed.
Yes. So the liability to be detained is like the warrant, I suppose, Lord Reid's analogy. There has to be the warrant in place for the detention, and it's achieved by various routes, and it disappears either by positive decision or expiry, and that's the nature of it. So it's not quite a clinical concept, and part of the problem, I think, with the Court of Appeal reasoning is they've been drawn into considering liability for detention as a clinical concept, and it's a forensic legal question. Yes. I'm grateful to my learned friend, Mr. Sands, for just pointing out another subtlety in the statute, and this is dealing with the restricted patients, Article 47. Which is, 2.
764.
47.2, yes, page 764. So the special restrictions applicable to a patient, respective restriction orders in place, none of the provisions in Part 2 relating to duration, renewal and expiration of authority shall apply. So the idea that your liability to detention expires by a lapse of time simply doesn't apply when you've got a restriction order. A restriction order is itself temporally defined or can be open-ended.
Yes, again, the pattern seems to be when a court has looked directly at this individual's case and made an order, that sort of takes over from what are the automatic default provisions that you get under the legislation itself.
The defaults don't apply. The Part 2 defaults are overtaken by the effect of the order. The order will specify times. It may have an identified time or may be open-ended. This one was open-ended, so that disengages those pieces of machinery, which again is why you've got to go back to the tribunal or to the Secretary of State and go to the Secretary of State in 48, which is on page 765. I've already shown you that. 48.2. Or failing that, you have to engage with the tribunal using 78 and 77. So,
well, the crucial words still are warrants is detention in hospital for medical treatment.
yes.
And the crucial construction is detention is liability to be detained.
Yes.
Yeah.
That remains the case.
The introductory words to Article 77, you only get into that if you are liable to be detained.
You already have the legal status. That's quite right. So, just to finish on the authorities, if I'm calling them that, but just so you have the references to this, the decision of CS, which is the with the evocative phrase about the gossamer thin grasp, is found at page 867. That's another civil patient decision of Mr. Justice Pitchford, and again a dispute about the extent to which there was clinical engagement with the patient. The principles are set out at page 879. It deals with section 17 leave, paragraphs 32, 33 and following. There's then a discussion of barking, Lord Wolfe at paragraph 37, the Holstrom decision at paragraph 38. And paragraph 39 again refers to Lord Wolfe and the questions that have to be asked. Cross-reference to Justice Wilson. And then an analysis of the facts of the case. I don't want to take up time with this really, but you'll see paragraph 44, viewed as a whole, the course of treatment should be seen. It's submitted as a continuing responsive programme during which the need for treatment, hospital and leave was being constantly reassessed depending upon the circumstances, including the responses to AOS and the ward round. And then there's a contest or dispute on that, a reference to the Holstrom case, which our Court of Appeal rely on. And 46, the Court rejects that. It's clear to me, second sentence, the RMO was engaged in a delicate balancing exercise, which she was, with as light a touch as she could, encouraging progress to discharge. Her purpose was to break the persistent historical cycle of admission, serious relapse of admission. It may be that in the closing stage of the treatment in hospital, her grasp on the claimant was gossamer thin, but I view that grasp insignificance, in my view, to misunderstand the evidence. So helpful, but part two, and Ms. Justice Colton referred to it. It's not critical for a part three case to have those factors in play. But we say again on the facts they are in play in this case, and the treatment plan and the prognosis for this patient would have met those considerations. Can I then turn to the Court of Appeal's decision, which you'll find at page 69 of the core volume. So, the factual history of the case is set out, paragraphs 2 onwards. I won't read through these, but it's quite a circuitous route to litigation. You'll see there's a reference to the 2019 tribunal decision, paragraph 3. And at this point that the RMO at that time considered that the patient could be conditionally discharged. At that juncture, you'll see at paragraph 5 the reference to the decision and that the problem of discharging someone to conditions amounting to detention or deprivation of liberty was unlawful. And that was the scenario they were looking at in respect of this particular patient.
So is this right? There was a bit of a mismatch between what the RM thought was a sensible way of dealing with the patient and what was legally available.
Yes, exactly. It wasn't legally available.
No, it wasn't legally available, and we don't know what the RM thought if he was told, well, you can't do that.
Yeah, he thought it was on the menu. It wasn't. It was off. So then everyone sent away to think again. Paragraph 6, various routes are being considered. Declaration in the High Court through the inherent jurisdictions considered. There are, in fact, applications to the High Court. You'll see reference to Judgment of Mrs. Justice Keegan there. A declaratory relief application which was adjourned without actual determination. The patient brought a habeas corpus application for the High Court. That's referred to at paragraph 9, page 73. That was also dealt with by Mrs. Justice Keegan. She refused the application, and for the reasons set out there in the quotation, he was lawfully detained under the mental health order, and the tribunal still had the case for determination. Then paragraph 10 brings us up to date with the 2021 tribunal decision, and this rehearses what I've already shown you from the tribunal decision, paragraph 37. This is the clinical evidence, and we say if we were applying the civil patient authorities, for want of a better word, CS, etc., this profile of care plan and treatment would meet those, and detention would be, or the conditions would be met. Of course, we're a Part 3 patient, which the Court of Appeal don't really grapple with in their consideration of this case. So, further discussion of the evidence, but the evidence in paragraph 10 is important ultimately to the overall analysis. Paragraph 12, they refer to the CS decision. Paragraph 16, they refer to Justice Colton's decision and to the various English cases that he discussed. And then they move into a consideration from paragraph 20 of whether or not the legislative frameworks are the same in England and Wales and Northern Ireland. So paragraph 20 onwards is the reasoning. And you'll see this didn't feature in the High Court and doesn't really feature in the argument up to this stage. They then say at the bottom of that paragraph that there should be a high degree of caution when considering English authorities dealing with the provisions of English legislation. Notes that there are many strong similarities, but then sets out differences from paragraph 22. So the first difference that the Court of Appeal identifies is in respect of the admission for assessment criteria in Article 4. And the Court notes that they're practically identical in the first stage. Then at paragraph 23 says the second stage, substantial likelihood of serious physical harm, is different, but they then say that's irrelevant to this case. Paragraph 24, they go back to the Article 4.2 analysis and say actually the definition of mental disorder is different, and that's correct. The definition of mental disorder is different as between the Northern Ireland legislation and the English legislation, but it has no bearing on the issues because the difference is about personality disorder, and that's not in play in this case. That's not a relevant or material point of difference between the cases. So the focus on Article 4 and the minor differences there is misplaced. They then turn paragraph 27 to Article 12 of the 86 order and compare that to Section 3 of the 1983 Act. And we've already done that exercise. We've looked at both of those. And the Court of Appeal says it's immediately apparent that they're very different. And the difference they identify is in respect of the warrants versus makes it appropriate test. They say the Court's view, the use of this phrase in both Northern Ireland provisions is very significant in the context of this case. So Northern Ireland uses warrants, English provision for Section 3 uses makes it appropriate. They say at 28, it's important to clearly define what the word warrants means. There can be no doubt that warrants in this context imports the concept of strict necessity. Not sure we go all the way with that in terms of strict necessity, but it probably connotes necessity. Then they quote from the South London and Maudsley NHS Trust decision of 2013 in support of this analysis. And I think I foreshadowed this earlier in a discussion with Lord Sales. The Maudsley decision, if I could just turn to that for a second, is at 1127 of the bundle. Must be the second one. Yes. Upper Tribunal decision 2013, Mr. Justice Charles, and he's examining the validity of Section 17 leave. And if you go to paragraph 10, you'll see what the issue is. There's common ground that the patient has a mental disorder, she needs a cognitive assessment, she needs treatment in the form of taking tablets. The way in which the case for discharge was put is not that she be discharged home, she should be discharged from Section 2 detention in hospital. The argument is, as she will not stay there on a voluntary basis, her Section 2 detention is not necessary, so it's not warranted. The word used in Section 2 and Section 72 Mental Health Act, if those provisions are read compatibly with Section 5(1)(e). So it's a Section 2 assessment type case. If you look across to the top of page 1131, you see the correct approach in law to the issue, whether the compliance of a person to remaining in hospital for assessment or treatment leads to the conclusion that his or her detention under Section 2 or 3 is or is not warranted. Now, of course, we know that 2 and 3 are different. They're not exactly the same. One's warranted, one's makes it appropriate. Then go to paragraph 15. There was no dispute before me about this, and all parties accepted, as submitted on behalf of AM, that to be compatible with Article 5(1)(e), Sections 2, 3 and 72 of the Mental Health Act have to be applied on the basis that for detention has to be warranted, it has to be necessary, in the sense that the objective set out in the relevant statutory test cannot be achieved by less restrictive measures. So what the court's saying, or the upper tribunal are saying here, is 2 and 3, and one makes it appropriate and one is warranted, has to be necessary. Now, that might be an error, or it might be something that arises from the fact that the parties agreed it. But this decision is not authority for there being a difference between Section 2 and Section 3. If anything, it supports our argument that they are synonymous. 2 and 3, warranted and makes it appropriate, are saying the same thing. But going back to the Court of Appeal, they rely on this passage, page 80 of the bundle, as support for confirmation of the interpretation that warrants and makes it appropriate are different, that one's a test of strict necessity and the other is something lesser. We say that it doesn't support that proposition at all. In fact, it's either neutral or confounds it. So then refers to Section 3 as setting out the conditions. And refers to making it appropriate. Of course, that's the provision that we're dealing with here. Paragraph 30 refers to the test of necessity. Does not mirror the appropriateness test set out in the England and Wales legislation. The difference in wording is clearly significant. It must mean there are material differences between the two tests. The use of the same wording for admission of assessment, the test for detention in Northern Ireland is also clearly significant. This can only mean the necessity principle is firmly embedded in both tests. Go back to our winter work submission. In order for the whole scheme to be Article 5(1)(e) compliant, then right across the board, English, Scottish and the Northern Irish statute all have to have the concept of necessity embedded. And we say it is embedded because makes it appropriate is synonymous with warrants. And the Court of Appeal have taken a wrong turn here.
One might think you'd have got there without winter work.
Yeah, you may not need it.
Because the common law isn't.
Yes, the common law gets there. I mean,
isn't particularly cheerful about locking people up who haven't been convicted of offences and so on.
Yes, well, winter work bolsters the point. Lord, that's all. If we need it. That then leads into the discussion of some other minor differences about hospitals and so forth. Again, we don't dispute paragraph 31. There are textual differences peppered throughout the legislation. But what we're looking for is conceptually significant legal differences on the relevant criteria for a Part 3 patient. And we say there aren't any. Paragraph 32 the judge or the court moves into a consideration of the CS case. So this is whether or not there's sufficient contact.
Well, it's the sentence before that, which is the jump, which troubles me. In 32, it would appear that the courts in England and Wales, in the interpretation of Section 3, have introduced a degree of flexibility in what is meant by medical treatment in a hospital, which reflects the threshold test of what is appropriate. That seems to me possibly a non sequitur, that even if they were right, that the test for detention is somehow less stringent, and I fully take your point that it isn't, why they think that that would explain a different definition of medical treatment or a different approach to medical treatment.
There's no connection.
On the contrary, you might think that the court would say, given that the threshold for detaining somebody is less stringent in England and Wales, we would expect to see much more intrusive medical treatment being needed in order to justify it. That seems to be the step that they take.
Yes, there's a leap there, and again, you'll see the focus here is on Section 3, and in paragraph 33 on Article 4 and Article 12, on the entry conditions through Part 2, and this, of course, is a Part 3 case, so it's a different issue altogether. Then they set out paragraph 34 what the how a tribunal should approach these issues, and set out an ordered sequence of questions beginning in paragraph 34 halfway down. Firstly, secondly, thirdly. These aren't particularly contentious.
Do you agree with the definition of the second one? Because it might have been slightly overtaken by Rumen against Belgium.
Yeah, I think there's more to be said about that. I think Rumen possibly postdates this decision.
2020, you're quite right.
Yes. So I think that has to be read in light of the Strasbourg, more recent Strasbourg decision. The third question, you'll see they refer to warrants and put in brackets necessitates. There's a bit of a gloss. We don't object to that, but we say the same parenthetical gloss could be put on, makes it appropriate. We say there's not a difference there. And you'll see paragraph 35, then they dive a little deeper into the third question and go into a consideration of the types of conditions that will never warrant detention for medical treatment, and identify the test as being more stringent. Paragraph 37, and they say it may appear obvious, but it doesn't need to be restated. The power vested in the RMO to grant leave of absence only applies in circumstances where the grounds for detention under Part 2 of the 86 order exist at that time. Well, that's not quite right, because Article 15 is also available for a Part 3 case. But again, we're looking at
that goes back to the discussion that we had about it, that the grounds for detention don't just evaporate at a certain point. There has to be a decision.
Well, that's why it's very important that the court seems to be looking at the wrong part. And Part 2 conditions do evaporate. Part 3, well, they expire by a lapse of time, or they can be discontinued by the RMO. Part 3 is rather different. You'll see then, top of page 84, paragraph 38, the problematic findings in respect of Article 15 leave. So the court's of the view that rather than taking into account the likelihood of Article 15 leave being swiftly implemented when considering impairment and so forth. They should have directed their minds to the questions in 34 and 35. The court is firmly of the view that it was inappropriate for the tribunal to conclude the statutory test for intent was met when the stated intention of the newly appointed RMO was the applicant appellant should reside on a long-term basis in a community setting, initially on Article 15 leave and thereafter as a conditionally discharged patient, provided the conditions that were then deemed necessary did not themselves constitute detention in the community. Now, we say it's entirely right for that to have been done. That's what should have been done. That's what the role of the RMO is. That's using Article 15 as it should be used to taper off risk and to manage a patient back safely into the community. What the RMO was proposing was a textbook application of the provisions of the mental health order, and the Court of Appeal says it shouldn't be done. They then approve of the passage of McCulloch, Justice McCulloch in Hallstrom, and I think I've shown you already the decision of Lord Wolfe in Barking, which the Court of Appeal don't refer to, where the Hallstrom decision is doubted and not followed. But that's relied upon by the Court of Appeal in paragraph 39, and they then go on at 40 to conclude there's no doubt that this is a valuable and therapeutic tool, as Article 15. Nothing in this judgment should be interpreted as meaning it's seeking to place obstacles in its way. However, Article 15 cannot and should not be used as a mechanism for providing legitimacy for what amounts to detention in the community when the grounds for detention or medical treatment no longer exist, and it cannot and should not be seen as a means of avoiding the difficulties presented by MM in respect of conditions which can be imposed upon a patient who is subject to conditional discharge. We say that's gone completely wrong at that juncture. It misunderstands what Article 15 is for. It fails to appreciate that's a critical tool in the toolkit for managing these patients, and there's no reason why it cannot be used. And it doesn't flow at all from the analysis about differential tests, which we say is flawed anyway. But even if it wasn't flawed, then Article 15 is still applicable. So paragraph 41, they say the tribunal got it wrong, didn't apply the correct legal test, justified their decision by reliance on the English line of authority, rather than applying the different statutory test that's applicable in Northern Ireland, and the trial judge got it wrong for the same reasons. So there lies the important question of principle, which we invite this court to grapple with. Is there a different statutory test applicable in Northern Ireland under the mental health order, as opposed to that which applies in England and Wales under the Act? In our submission, the difference is not a difference at all. It is synonymous language, makes it appropriate, is equivalent to warrants, both of which connote necessity, which align with the Article 5(1) obligations to only detain when the winter work criteria are met. So, for those reasons, ultimately we say the Court of Appeal have fallen into error, and an error of some importance that requires to be corrected. I've actually used more time than I thought I was going to use, but I think that those are our submissions subject to what I say in reply.
Thank you very much, Mr. McAleenan. Mr. McMillan.
Thank you, my lords. My lords, my ladies. Just, my lords, ladies, on the question, a couple of factual issues. Dr. McAleenan mentioned just after lunch, short adjournment, that RM was given a period of leave, in fact, leave in the facility we discussed in the papers. Now, that commenced on the 29th of March 2001. And on my instructions, RM has not at any stage for any purpose returned to the hospital that he is putatively detained in, and on the basis of which his detention is being justified. The RMO, seen his name in the papers, the second RMO, in fact, as far as we're aware, is not even based in that hospital himself. And I withdraw that from both common knowledge and also from the address on his reports, which is another healthcare facility. So the connection that justifies RM's detention, that warrants his detention in hospital for medical treatment, is something that has not called upon him to attend the hospital or even the RMO to be present at the hospital. Now, one could almost leave our case there because the link with the hospital detention relied upon by the appellants in this case is, we submit, of the most arbitrary nature. It's sheer happenstance that there is any connection put forward. What would happen, for example, if the RMO was transferred, as he could be, to another facility, to work in an office in Belfast, the headquarters of the Health and Social Care Trust? And is it right that in the context of Article 5, the detention of a man from 2017 until what's going to be effectively into 2024 can be justified on the sheer coincidence of where the RMO happens to be based? And that's particularly important in a case where there's not an ongoing therapeutic reason for the individual to go back to the hospital. So that's the context we're in this case.
But if I may say so, perhaps it's not justified on that basis, isn't it? We've been exploring all day how the Act works. Isn't it justified on the basis of the authority to detain given by the Act and the fact that an RMO has previously said that this authorises detention in hospital?
Of course, my lord, and that's the very reason one goes to the tribunal, because there is that authority that warrants. So one turns up at the tribunal and one says, yes, of course I've been detained under a valid order of the court, hospital order of the court. The patient will say, I'm asking you to discharge that order. And the reason I'm saying that is because there's no longer a reason to detain me in the hospital for treatment. So one effectively then considers whether that authority should continue. The simple fact that it has existed up to that date, of course, cannot say anything directly on whether it's appropriate to extend it further or not to cut it short.
So do I gather from that you accept the discussion that we've been having about what liable to be detained at the beginning of Article 77 and Article 78 is? It's to do with whether there is in place the legal authority for detaining someone, even if it may, it turns out, have been based on, or the justification for it may have disappeared some time before.
Yes, my lady, I think it's perhaps very important that I actually turn to the statutes, so the court's perfectly clear what I say about the statutory scheme. And I'm grateful for Dr. McLean for carefully going through it in great detail, but that then hopefully is allowing me to turn straight to EF 781, and the court's obviously seen this. So what we have at Article 77 is the power to discharge patients other than restricted patients. Now, that will cover Part 2 patients. It will also cover those patients, if there are any such patients, where hospital orders have been put in place by the court, but no restriction order has been made. So it's wrong to conceive of Article 77 as being purely a civil matter. It can engage those persons that have been involved with the criminal justice system. And with that in mind, having regard to the nature of what follows in 78, obviously says where an application is made with a review tribunal by or in respect of a patient who is liable to be detained, the course may direct the discharge, etc. Now, the liable to be detained relates clearly to the Part 2 individuals and to the non-restricted criminal justice individuals. So, to that extent, it's perfectly proper and consistent with the rest of the scheme of the legislation that phrase is used in that place. But that does not relate to the position of those who are restricted patients.
But of course, it's incorporated into Section 78, which does apply to them.
Yes, but my Lord, one turns to 78.
Well, sorry, just before you do, 77.5 says paragraph 1 shall not apply except as provided in 78 and 79. So if 78 brings you back, then 77.1 does apply.
Sorry, yes, my Lord, your Lordship's quite right. I think I phrased that very badly. It's by virtue of 78.1a, that takes you back to 77.1a and b. So the question then, clearly anyone who is detained in the hospital because their detention is warranted for the purpose of medical treatment is also going to be within the scope of someone who's liable to be detained. So by using the broader term at 77.1, that encompasses anyone who could be detained under the Act.
But I think you accept that RM is a person who's liable to be detained. And,
he is, yes.
And I think, do you also accept that the word detention in 77.1a is liable to be detained?
No, my Lord.
Why not?
We submit that goes further because...
So that you would have to have actual detention in hospital.
No, my Lord, something can be warranted.
Okay, but just let me just explore it. You have a person who's making an application. He has a liability to be detained because he's on Article 15 leave. Okay. You then come to apply the test in 77.1a, and that person would be released unless he was actually going to be detained in hospital.
My Lord, the question is whether it warrants his detention. That does not necessarily, in our submission, require actual detention. For example, detention could be warranted in the case of a restricted prisoner, a restricted patient rather, yet he is on leave, as in the case of RM over the last 2.5 years. So we say, my Lord, that warrants detention. That's a crucial question at that stage. We have the catch-all term at 77.1, liable to be detained, that brings in everyone. But then when one comes to engage with the test itself, the question is whether detention hospital is warranted for medical treatment, which is a different test. And the fact that they're used in close conjunction, we submit on normal principles indicates that something different was intended.
And so does that mean warrants any period of detention?
It means at the time he makes the application and appears before the tribunal, the question is, at that time, is this detention warranted? So simply because historically it had been warranted, my Lord, would not be enough to satisfy the test.
I'm sorry, I'm afraid it's my fault. I'm lost a little bit. Do you say that detention is actual detention?
To be warranted, my Lord?
Yes.
Not necessarily, my Lord.
Okay. So isn't that the same thing as saying warrants his liability to be detained if it's not actual detention?
No, my lord. The tests are still distinct. Now, liable to be detained can cover, we would suggest, a wider category of persons than simply those who are warranted, where it's warranted. Warranted, we submit, suggests something more concrete and more demanding than simply that you're liable to be detained.
Well, I don't think that is the distinction. If you look at Article 78, the top bit replaces the words liable to detention in 77 with subject to a restriction order. So 78.1 doesn't talk about somebody being liable to detention at all. It talks about somebody who is subject to a restriction order, which rather supports the flavour we were giving to liable to detention being their status according to some decision that's been taken. But by incorporating paragraph 1A into section 78, it does then incorporate the warrants detention. Now, to my mind, the warranting his detention is a clinical test rather than a legal test, if I can put it like that. But the point still remains, as my Lord Stevens says, is what has to be warranted in order for the test to be passed.
My lady, I think your ladyship really exposed my point. The liable to be detained issue is the gateway issue into the test, and then the test posed for the tribunal is whether detention, in other words, continued detention in the future, is warranted. And as your ladyship suggests, that will be on the basis of the clinical evidence. So that is where we are. And my fundamental point is...
what do you tell the clinician? What do you tell the clinician when he's giving his evidence as to the test that should be applied? Do you say it warrants his actual detention? Do you say that it warrants detention on some occasions? Or do you say that it envisages some degree of detention? Or what?
Well, my lord, I would suggest that you simply ask the question, is his detention warranted? And in the evidence in this case, that is the question that the doctors have directly addressed. Really, the issue is whether they addressed it properly. And there was sufficient evidence to support their conclusions.
I'm afraid I've become a little bit confused now. It's my fault. Going back to Stephen's example, you've got someone who is subject to release under Article 14. Can they apply for discharge under Article 77.1?
If they're an Article or a Part 2 individual, yes, they could.
Right. So I'm not sure that it's taking the clinician very far just to ask, is his detention warranted? Because the clinician thinks he can be out in the community. That's an Article 15 case, ex hypothesi.
Well, one has to recognise that we're in a domain where it's not generally amenable to instant diagnosis and prognosis, and indeed instant treatments, as we all know. Clinically, the likelihood is that there will be a treatment lasting over a period of time. And Dr. McLean's quite right. One of the key prognostication tools is the use of leave or being tested in the community. So in most cases, what will occur is that during the period of treatment, in order to find out whether the treatment is sufficiently advanced to decide the warranted issue, one is tried out on home leave. Now, the difficulty that arose in this case is that the medical treatment in the hospital had completely concluded.
Well, it hadn't. It hasn't, because a crucial part of the medical treatment in a hospital is actually making sure that the patient is able to move from the hospital into the community in a satisfactory way for his benefit, for the benefit of the community.
Well,
as part,
my Lord,
you accept as part of the treatment.
We will come to the evidence in a short period of time, or less the court would like to turn to it at this stage. But the evidence from the first doctor was that all the clinical work in the hospital had ceased.
Yeah.
And of course, my Lord, we accept unreservedly that supervision of the period in the community, the testing in the community, can be part and parcel of that treatment.
I mean, it's not only part and parcel, it's a vital part of the treatment of patients. But it matters not. You accept that Article 15 leave is part of medical treatment.
Absolutely, my Lord.
Yeah.
We've never disputed that.
Yeah.
And indeed, a valuable part, clearly, my Lord. But the question is whether it's necessary or his detention is warranted in the hospital for that medical treatment. And when there is no meaningful connection with the hospital itself, because there's no ongoing, in the classic sense, treatment, and it's sheer happenstance that the person supervising happens to be in the relevant hospital, we say, my Lord, the detention cannot be justified on the basis that it's warranted.
How does he get his Article 15 leave if it automatically means that he's in the community and therefore doesn't warrant detention in hospital, treatment in hospital? How does he actually get it? I mean, the suggestion is made that completely removes the ability to provide Article 15 leave, an essential part of treatment, from all patients. How does he actually get it?
Respect, Lord, it's leave because he's granted leave by the manager of the hospital.
Okay, he needs, a patient needs, as a vital part of their treatment, to have a period of time when they're transitioning. How does he get that if as soon as you start transitioning, you are not receiving, you're not warranting detention in hospital for medical treatment? How does he get
Lord, I'm sorry, my Lord, I must have expressed myself very poorly.
Yeah.
It is a continuum. It's the case to say one will start off at a stage where perhaps one's allowed out for 1 hour a week, and that will be tested, or you may be allowed out for 1 hour a week supervised, go then to 2 hours, then 3 hours, perhaps unsupervised. So one has a continuum where there's reducing periods of engagement with the hospital and supervision by the hospital. And the issue then becomes, at what stage is that so minimal or so, in material terms, non-existent, that the connection to the hospital is such that it does not warrant your detention in the hospital for treatment?
There is a statutory definition of medical treatment.
There is, my Lord, and it's very broad.
As including
care and
training under medical supervision.
Absolutely, my Lord.
Right. So, as long as care or training under medical supervision is going on, medical treatment is being received.
Yes. It can be, but that's simply because one has some care or some treatment does not of itself warrant your detention in hospital for that
because
treatment.
It has to be not only medical treatment, but medical treatment in hospital.
Yes. Well, certainly a connection with the hospital. One could, for example, be an outpatient and in a community facility, and one would go to hospital. We've seen some of the cases. People go to the hospital for ward rounds every day, which then reduces, and they may go for psychology classes or sessions, and those will then tail off. And there then becomes a stage where the patient will go to the tribunal and say, this is at such a level that there is no connection worth talking about in terms of justifying or warranting my detention.
So do you accept then, therefore, the significant connection test as the applicable test?
Yes, my lord, I do.
Okay.
And whether what we say on the difference between whether it's appropriate to be liable to be detained or warranted detention, under either of those, no matter which way one look at it, this case would simply not pass muster, or should not pass muster.
Yeah.
Well, there's a bit of a mismatch between what you're saying and the actual decision which is being reviewed here. That the decision that we're reviewing is looking prospectively at the influence of the plan for Article 15 leave on the test that the tribunal has to apply before he's gone out into the community.
Yes.
Your submissions are saying, look, he's been in the community all this time, now there's really no connection, and so the test is not satisfied. But that may or may not be the position now, but this appeal is looking at how the legislation applies at the earlier stage, which leads me to a question. Is there some moratorium period between Article 78 applications, or can a patient make an Article 78 application at any stage? I mean, is there, I don't know, is there a provision that says once you've made one, you've got to wait 6 months until you make another one, or not? I don't know.
The one, Junior perhaps find the reference, one can make an application in the second 6 months. In other words, after the 6 month, you've been in subject to an order for 6 months. Do you have that? My lady, we will find you the reference.
Yeah.
And then one can make an application every 12 months thereafter.
Right. That would be useful to know that.
So
I think we mustn't be deflected from the decision which is under review to reviewing some decision that's not actually been taken.
Indeed, and that's one reason why we'll need to look at the factual materials in some length, perhaps tomorrow morning.
Well, we've got the finding. We have the decision of the tribunal. It's not. This isn't an appeal on the facts.
No, it's not. It's not.
It is not for us to retake the tribunal's decision on the evidence before it.
No, but Lord, I think one needs to understand what occurred and sequentially, and again the sheer happenstance of what occurred. When one's reflecting on the arbitrariness of the way RM was dealt with in all the circumstances, and just by way of background, we had the original RMO who said, no, all hospital treatment has concluded, he should be released. And then the issue arose.
But I mean,
Subject to conditions.
Yeah, subject to conditions, and the RMO didn't appreciate how limited the conditions could lawfully be. So
Yes.
we certainly don't know that the RMO thought it was a good idea to release him from detention.
Well,
He had
the first,
appreciated that.
obviously the questions have to be considered sequentially. The first one is the warranted test met? The RMO said no, the warranted test wasn't met, so he would then be discharged. The question then is, what form of discharge? Is it absolute discharge or conditional discharge? The RMO then said, no, we need these conditions, and the tribunal concluded that it didn't have the power to impose the conditions the RMO wanted. But what that did not do, and what the tribunal did not grapple with, is the fact that he had concluded that the conditions for detention no longer existed, and the only issue was the type of discharge. And I recognise it's easy for a lawyer standing here to tell experts in their field what they should do, but I submit that the tribunal should have said, well, we think there should be conditional discharge. Here is the list of conditions that the RMO thinks should be imposed. We can lawfully impose 1 to 8, but we can't impose 8 to 15. So it should have simply imposed the ones conditions it could impose.
But didn't the RMO, mustn't the tribunal or the RMO have been satisfied that it was appropriate for him to remain liable to be recalled to hospital for further treatment?
Yes, so that was an issue of what type of discharge. We were past the period, past the point of saying, yes, there should be a discharge. So the only issue was the type of discharge. And when it comes to conditions, the question is then, if it should be conditional discharge because he should be liable to be recalled, what conditions should be imposed? And the tribunal at that stage should impose the conditions it lawfully can impose.
This is all history. I mean, by the time of the hearing where the decision was taken, with a different RMO, his position was that a discharge wasn't appropriate, that Article 15 leave was appropriate. We're told by the tribunal that he not only submitted a written report, but he also gave evidence orally. And it's submitted, it's summarised, but he outlined the treatment under Article 15. He said a lot of personnel would be involved in assessing the patient's care needs and ongoing risk assessment and in providing regular refresher psychological support. Talked about his role as RMO. Now, we're no longer concerned with the issues you're trying to address us on. What we're dealing with is an appeal by Mr. McLean's clients based on an alleged error of law by the Court of Appeal. So it's the legal analysis of the Court of Appeal that's the focus of our discussion.
Entirely acceptable, my Lord. But the legal analysis on the basis of the facts presented to the court, and that included the materials, factual materials before this court. But one doesn't need to go through the entirety of the materials to discern that the only difference between the first RMO and the second RMO, they both agreed that the assessment and care work and additional work had to be carried out at the community facility. But the only difference that they had in their opinions was that one thought the fact that you were supervised by the RMO, or the arrangements were supervised in a general sense by the RMO, meant that there was still an element of treatment at the hospital which warranted detention.
Well, it is true. Not only that. I mean, for example, the earlier RMO thought that the Knockcairn staff had the necessary training, expertise and knowledge to manage and safely maintain the patient. Dr. Devine took a different view and felt that the staff there weren't in a position to provide.
Yes, and those individuals could and would be trained as they were trained. And one can defer, of course, one can defer conditional leave until the arrangements appropriate for the conditional leave, or conditional discharge, rather, have been put in place.
Yeah.
So,
but I think we're being taken down a road which is not the focus of this appeal at all.
well, I understand entirely, my Lord, the general proposition that one, this court will not examine the facts closely. But the question is, what were the courts looking at? What was the justification in this case for the detention of this man? And why was the detention warranted? And it was warranted. The only reason it was warranted is that the second RMO thought that because he had general oversight of the care and management of RM, that meant that there's sufficient link to justify detention.
But wasn't the RMO's decision must, where I take issue with what you're saying is that there are sort of two unconnected steps. You apply the test, is his detention in hospital warranted? Yes or no? If no, then you go on to consider what conditions you need to apply. But I would take issue with that. I would say that actually what the RMO is saying is, provided that he can be subject to these conditions and he complies with them, then I'm satisfied that his detention is no longer warranted. But if he can't be subject to those conditions, then his detention in hospital is still warranted. So I see at the moment the conditions as feeding back into whether the test is satisfied, and that another area where the Court of Appeal may have gone wrong is in splitting those two stages and saying they have to be considered separately, whereas in fact I wouldn't think that would be how a clinician would approach it. They would say, as long as he can be ordered to stay away from a school, for example, and that can be enforced, then I'm satisfied that he's not at a risk to children. But if he can't be subject to that condition, then I'm not satisfied that he's no longer a risk for children. That's my concern with the Court of Appeal's structured approach.
My lady, I understand the concern, and I understand, of course, what your ladyship says. But the issue, if the issue to be considered concerned the safety, the 77(1)(b) issue, safety issue, all your ladyship's concerns would be at the forefront of the clinician's mind and the tribunal's mind in particular. But when we're on 77(1)(a), we're looking at, is it warranted for treatment? Is detention warranted for treatment? And the issue as to the conditional discharge logically only really follow that. One decides that issue first. And it's not a safety matter as such at that stage.
The same point applies.
The same point applies, though, or does the same point apply under 77(1)(a), that the question of whether his detention is warranted in hospital depends on what the alternative is, and the alternative is what conditions he can be made subject to.
Well, lady, that would be correct if the imperative of the statute was containment. But it's not, that is not the test, my lady. It's treatment. Treatment is warranted for treatment of the individual. And there, of course, can be some overlap between treatment and safety, public safety issues, but the focus is squarely on the treatment of the individual, not the safety concerns when we're looking at 77(1)(a).
But say the clinician takes the view that the patient has reached a point where testing of the situation is required, and takes the view if there is testing, then treatment in hospital is no longer warranted. And the first RMO appears to have taken the view that testing could be done by the imposition of conditions, a condition that he attend a community facility in order to, I don't know, have urine testing or to have whatever other supervision or testing is available. Without those conditions, the clinician would have said, he's still got to be detained in hospital so that we continue to monitor his position. But the alternative might be Article 15 leave with that sort of supervision, testing, care continued on a progressive basis so that one could see whether it was ultimately safe to conditionally or absolutely discharge.
With respect, that's precisely probably what should have been done.
But isn't that what did happen? The first RMO said, let's do it by way of conditions, under a conditional discharge, didn't realise that that was not possible. The second RMO says do it by way of Article 15 leave.
The first RMO said all hospital treatment is complete.
Because we can impose conditions.
Well, lady, there is no question of any other connection with the hospital after, it appears in the first RMO's mind. Once the order was made, conditionality had nothing to do with the hospital per se. So the connection with the hospital would be broken at that stage. So it wasn't a question of the hospital testing via leave.
All right. What about the second RMO?
The second RMO, his point was leave should have commenced at an earlier stage before treatment was complete. If that had occurred, we wouldn't be here, quite simply. That's a perfectly valid approach. But what one cannot do is rewind the clock and say, okay, we realise that the hospital treatment is complete. We then encountered the issue from we couldn't impose these conditions. Therefore, we have to unpick everything and, in effect, create this connection with the hospital to justify his continued detention.
So you say it's just a device?
Absolutely, my lady. And if the court will bear with me for a period tomorrow, hopefully a short period tomorrow, I'll take you to the key passages. It was, with respect to a device with the very best intentions, and I just pausing there, I do not suggest that any of the clinicians or anyone else acted in other than...
Well, of course you can't. You haven't even got a cross appeal.
No.
There's no question of your trying to impugn the decision of the tribunal on any other ground than the one that was upheld by the Court of Appeal.
But, my Lord,
it's the Court of Appeal's reasoning which is an issue here.
Of course, my Lord, I simply want to make that point absolutely clear, because it's a public forum.
Could I clear away some of the undergrowth, as it were? You accept that there is a severe mental impairment?
There is.
Yeah. You accept that he needs medical treatment in the form of Article 15 leave? You have already accepted that?
He has Article 15 leave.
Yeah. And his medical treatment? Yeah. The question mark is whether it's in hospital.
Yes, whether it warrants detention in hospital.
And you accept that he's a risk to others, and that can only be met by depriving him of his liberty?
Well, my Lord, not at this stage.
No, at the date of the decision.
Yes, my Lord.
Yeah. And well, there we are. So the only issue is whether it's in hospital.
Yeah, whether it's sufficient hospital element to justify his detention in hospital. My Lord, I appreciate our position is an absolute position, and one needs to be realistic and operate in the real world. We recognise that. But it is a binary test posed by Parliament. So, particularly in the context of Article 5, my Lords, ladies, that simply because there's a difficulty does not entitle the state or the doctors to go back and impose detention when it would not otherwise required. See, my Lords, ladies, it's 4 o'clock. Sorry, forgive me, it's my Lord Junior. Refers me to Article 75 at page EF 780, relating to Lady Rose's question as to the time periods for the making applications.
Sorry, I didn't get that. Article 75?
Article 75 of the order at EF 780.
Yes.
So, as I understand, that just sort of controls how quickly you can
Yes,
come back
just
to the tribunal.
It relates to the very discreet point from my lady.
Thank you. Well, I think that's a convenient moment for us to adjourn. We'll resume tomorrow morning at 10:30.